he was going to come in my yard. You'd be like, oh, did he come in your yard? No, then you can't pull a rifle on somebody.
There's 3 defenses to any criminal charge. Didn't do it, didn't mean to do it, and crazy.
Innocent till proven guilty.
Exactly.
And if they can't prove it, then you're innocent.
Right.
Came downstairs, sure as hell, they're chasing him, and he literally was shooting back at them. He was shooting this way. You can believe that he's did it. He's got to be guilty. There's no ifs, ands, or buts about it. But if the state doesn't prove that he did it, you still have to find him not guilty.
The burden on the state, we've talked about this many times, and the government is they have to prove everything beyond the exclusion of every reasonable doubt. Every element. He's back here with us in full force, attorney and my trial partner, Larry Schweiker. Welcome back, Larry.
Danny, how are you?
I have my other trial partner, Michael Dye.
Welcome to Two Taps and Friends. Grab your favorite drink, get comfy, and let's dive into another episode of Two Taps and Friends.
Welcome back to Two Taps and Friends. I'm Daniel Rosenberg, host of the show, and today I brought my esteemed trial panel on. I have back for a while, hasn't been back in a while, has had some stuff going on, but he's back here with us in full force, attorney and my trial partner, Larry Schweiker. Welcome back, Larry.
Danny, how are you?
I have my other trial partner, Michael Dye, here. He's been on very frequently. He's pretty much a co-host on the show. How we doing?
Doing fantabulous.
He's here with the famous rubber ducky shirt. But
You just got a Jeep.
They're the one.
yeah, the one. Well, I brought you guys on because I thought, you know, Larry and I have a murder trial coming up, and we're preparing for it.
No, we're not. We're doing a podcast. We're not preparing for it.
Well, you know, in the off time, we're preparing for it. Not joking. We clearly are preparing for it. But I wanted to talk murders with you guys and trials and the different preparation that goes along and the different defenses that go along because, you know, in the media, what we see more than anything are murder cases. It's what's juicy. It's what's you know, what everybody's covering, what the podcasts are covering, and all that kind of stuff. So, and the number one thing I want to talk about are defenses first of all, starting with there, you know, because people throw around self-defense. Always, for everything. That's what non-experts become experts when it comes to self-defense, right? With gunshots and shooting, and we see this a lot, right? With like gun charges, right? Oh, I was defending this, I was defending that. I'm like, okay, well, you can't pull a rifle on somebody, you know, because you're, you know, well, he was going to come in my yard. Be like, oh, did he come in your yard? No, then you can't pull a rifle on somebody, right?
What's funny is that you see, yeah, we see a lot of murder trials. As lawyers, we've got to be like, what's the biker version? Like 1%ers.
Right.
When I was in law school, we had whatever discussion was going on, we had this discussion, and one of my professors, she was a trial lawyer, a litigator or something, which is really rare.
Right.
Very, very rare, apparently. And we were having a discussion, she said something, and her comment was, I'm a person who represents murderers and rapists, and whatever she was talking about. And everyone's just like, oh my God, she does represent murder and rapists. This is all we do now.
Right.
I remember that phrase, I'm thinking, yeah.
Yeah.
Why was everyone so shocked about that? We are a very rare breed that gets into in the big picture of lawyers.
Right. I mean,
corporate lawyers, government lawyers. You have criminal law is a narrow focused thing. Trial lawyers are much
even
more
narrow, right?
And even more narrow is the actual homicide stuff.
Right. You're
In
getting
Florida, you do that death penalty. You got to be certified for that. You
Right.
can't just wing it and do it. So.
100%. First of all, accused of, not always did it, right? Like, let's differentiate
What
that.
is it?
Alleged murders. You said murderers and rapists, but you know.
No, we
accused,
represent them.
right?
We represent them.
We're going back in circles.
You may allegedly represent people. I
Yeah,
represent
no, we definitely represent them, but you know, we represent alleged murderers or rapists. Is what I was joking about, but it doesn't matter. But either way, what are you going to say? You going to add something on?
No.
Oh, I thought you were going to say something. No, so, but first of all, talking about some of the defenses, you know, what the best defense for any trial is, in my opinion, in experience, is ID. You guys agree? Meaning, wasn't there, wasn't me, wasn't there. Do you agree with that?
No.
Yeah, well, if it's true. Yeah.
Well, but first of all, it adds another step for them to prove, right?
Yeah.
Right? Clearly, if you were there, that's not a defense, right?
Well, I mean, I think I told you there's 3 defenses to any criminal charge. Didn't do it, didn't mean to do it, and crazy.
Right.
And so every defense is one of those.
Right.
So when you're saying didn't do it, now you're talking about an alibi defense. If the alibi defense holds up, yeah, it's great.
Yeah, but didn't do it could also mean didn't
Well, it
meet
wasn't
the
me.
elements of the crime, right? Like, of a self-defense, right? Self-defense. They're saying, like, the issue that with self-defense that people don't understand, especially in trials, like, you put yourself there. You know what I mean? Like, if the state is able to establish that the person, or the government is able to establish the person who's actually on the scene, you know, clearly self-defense is something that you need to go,
What are
especially
you talking
with
about?
murders.
Affirmative defenses. If you have an
Right.
affirmative
Yeah,
defense,
talk
like
about that a little bit,
self-defense,
right.
that's exactly what it is. Yes, I did do it, but I have a defense toward it. That's it. And that gives you, that's what a defense is, not as opposed to I didn't do it. Your defense isn't I didn't do it, it just wasn't me. That's-
Right.
But the problem with the affirmative defense, I mean, affirmative defense is, well, you can start it off with, I did it, but.
Right.
And then you have to have a legally justifiable excuse after the but.
Was
Right.
that going to one of your three things, though?
So, and it goes into, I didn't do it.
Yeah, that's what we were saying. It categorized it, I didn't do it.
I did do it, but I'm allowed to have done it. That's not really. I didn't do
So,
it.
you know, it's not murder because I was allowed to kill him.
Right.
So,
But there's been situations in cases before, we're not gonna name names, where in the middle of trial, I think you were part of one with me, where
This is a previous podcast, I think.
yeah, we had to shift focus, like, you know, all of a sudden we saw it, first of all, not knowing whether our guy is guilty or not, because a lot of times, we don't ask that question, right? That's a question you try to avoid asking, because it's not about whether they are, it sounds crazy to say that, but it's about whether it can be proven,
It's
right?
not really crazy to say that. It's kind of a constitutional law.
Agreed, but to a layman hearing that, they say, what do you mean it's not about that? Saying it's about what the state of the federal government can prove, right?
Well, you're
So-
innocent till proven guilty.
Exactly.
And if they can't prove it, then you're innocent.
Right, but sometimes mid-trial, all of a sudden you're realizing they're able to prove that the person was actually there. So you have to now, you know, and now you start to question the client a little bit, right? And they're like, well, you know, then they start to give you separate affirmative defenses, and you got to shift
Well,
mid-trial.
you could technically argue that in front of a jury. You can, I would never do this, I don't think, I hope
Right.
not. To say, it wasn't him, but if you think it's him, he had a defense, it was self-defense.
Yeah,
well,
You can argue that, but-
You can present conflicting theories of defense.
Right.
Where, if this, if this, but the state's not allowed to have conflicting versions of prosecution.
right.
Yeah, but you can't say,
So-
5 guys identified him. Well, if you would believe all those 5 guys, then he actually shot him in self-defense. Because
It's hard
you
to
hit
say.
you hit the nail on the head. Most people don't understand that. And that's who our jury is, most people. Jury of your peers? No, not people that would shoot somebody possibly or defend themselves. It's rare. So you have to go with one or the other in
Yeah,
reality.
Like Larry's saying, what he's pointing out to, like Michael's like, as lawyers, yes, you can present that. But as a juror, that's not a lawyer hearing, they want to know what happened, right?
Exactly.
They want to dumb it down. Did what they say happen, or is what you're saying happen? It's almost like we're forced to now paint a picture where we're not supposed to.
So the best example, I guess, is what we use like a domestic violence battery. In a battery, you have the harmful or offensive touching of another without their consent. And
Right.
you have to have that element without their consent.
Meaning
So-
they have to come and testify with
Right.
live testimony that it was against their consent.
Now, there's a couple, for all those lawyers watching this, there are a couple extenuating things that can happen.
Right.
The 9/11, whatever, hearsay
911
exception.
911 tape,
911,
right.
yeah. So, but barring that, they have to have the element of without their consent.
Right.
It probably resolves back from football or something like that, where we all agree to hit each other. It's not a battery, that type of thing. Now, on an aggravated battery, where you either use a weapon or you commit serious bodily injury, you don't have to have the element of without their defense. So if I have a witness that
Without their
sees you.
consent, sorry.
Well, yeah, without consent, yeah. So if a witness sees you stab somebody and the victim's not around, or they don't want to come in, they still can go forward with that case.
Right.
So that's why you have, it's an affirmative defense. You have to, the burden shifts to you, and you have to go ahead and prove that it was a self-defense at that point.
Right.
And the problem is, on an aggravated battery going one step further, without the witness, hey, an eyewitness said that it was, I saw you stab him from afar, and then you said, well, now it's self-defense. It's the whole thing we were just talking about. The burden shifts, but he said he's going to kill me. Looked like he had a gun in his pocket. The witness wasn't there to that, all that stuff. So now you put on an affirmative defense, and if it's not rebutted, that defense stands.
Right, so affirmative defense, just for laymen or people listening, not lawyers, you know, the burden on the state, we've talked about this many times, and the government is they have to prove everything beyond the exclusion of every reasonable doubt. Every element, it's on them, like nothing for defense. Like we joke around, in jury selection, we talk about, you know, I could be sitting here reading the funny papers, when we still use that joke, as if the funny papers are still around.
I say play tic-tac-toe.
Or whatever it is, right?
Angry
And
Birds.
they have to do everything. Are you okay with that? We do that to kind of make sure to hammer away that concept that the burden is all on the state and federal government. Do you think it's fair? Do you think it's not fair? That's what we ask them. When it comes to an affirmative defense, like self-defense, that burden, for the only time in trials, that burden shifts to now the defense has to prove that at least allege or prove or allege that this is a self-defense case, and then the government then has to go back and rebut that it was, you know? But if we don't do that, then, you know, you can't really do it.
You hit on a really interesting thing. How many people, they always, in voir dire, when we pick juries, they always say, yes, we can follow the law, we can follow the law. I always want to say to a jury, you can truly believe my client's guilty. I could tell you, well, not tell you he did it, but you can think he did it. You can believe that he's did it. He's got to be guilty. There's no ifs, ands, or buts about it. But if the state doesn't prove that he did it, you still have to find him not guilty. Now, you can't say that to somebody. You'll be like, no, if we believe he's guilty, he's guilty. And that's the reality of it. Unfortunately, they don't follow the law because the state barely proves their case. We always
Right.
bring up what reasonable doubt is, a lack of evidence, conflict in evidence. You always bring that out, but no, we believe he did it, and that's it. It doesn't matter. So the state doesn't, it's really weighted the other way, even though the burden's all on them. Back to the human element factor, doesn't matter.
I
At some
think-
point, we can have artificial intelligence decide the state didn't do prove enough of their case, guilty or not guilty.
I think that's why they stack it against the statutory review
Yeah,
system.
I was going to say, the problem with affirmative defenses is that you have to admit half of it.
Exactly, that's my point, right?
You've got to go ahead and say,
But you're
yes,
halfway,
I did
you're
it.
there already. The five guys that said you did it already.
Right,
gave
at
you
that point, you have no choice.
Exactly.
But if you don't have that, to come out the gate saying that, I think you're doing half their
Florida
job.
took it even further with the stand your ground statute.
Right.
Well, everybody's got the stand your ground statute messed up. Everybody
Let's
thinks
explain
that.
the stand your ground statute, because I know lawyers are confused about
All
that.
right,
Talk about
basically-
it a little bit.
Easy.
Boy Wonder, give us
If
the
you are
interpretation.
if you are legally where you are allowed to be, and somebody is going to physically harm you, and you are in fear of great bodily harm or death, you can use
Deadly force.
Deadly force before you don't have to retreat. Under common law, you had to attempt to retreat from the situation before using deadly force. In Florida, the only thing is now is you don't have to try to retreat.
Right,
right.
but that needs to be played out, right? So like,
Well, there's more to it than that. The state loses jurisdiction to prosecute you because you don't have a duty to retreat. That's
Correct.
the idea of it. It's a motion to dismiss based on the fact of no jurisdiction. So that's the whole thing. It basically took our old school castle doctrine where your house is your home, you could kill anybody. The old saying for the people that are our age, or my age, oh, if you shoot somebody, make sure you drag them into your house first. That was the whole thing you used to say. Now it doesn't matter. Now you don't have to drag the body into the house anymore. It applies everywhere. And they took the ball and ran with that.
well, it leaves the part of it up to a lot of interpretation, though, right? So like, you're in reasonable fear of death, right? So like, if I'm sitting on my front lawn and I get into a shouting argument with somebody and I put a gun on my lap and that person, and then that person shoots me, like, who's in the right there, right?
Yeah, because it's very fact specific.
Right, you get what I'm saying?
No, is it a reasonable person standard or is it a
rea-
subjective fear
Well,
standard?
they apply a reasonable person standard to it, but the bottom line is, it used to be force with force, or to meet force with force.
Yeah.
But that's not the situation anymore.
Right.
And the old adage you taught you at law school, if someone comes up to you with a knife and a blowtorch, oh, wait, what do I have here? I got a knife, I got a gun, wait, I don't have one of those, let me
Yeah,
come
right,
back.
doesn't make it,
You don't have to
doesn't
meet equal force.
Right.
But that doesn't apply as it is said, but, it can be a karate person, but, that whole theory that you have. If he knows jujitsu, I can shoot him because he's.
If he knows jujitsu, I'm just going to kick his ass. I mean,
Oh, God.
There you
They're
go.
going to say, there's a lot of jujitsu guys watch this podcast. Be careful what you say,
He's not with us.
Yeah,
Get the
but
duck shirt.
I think,
But,
go ahead.
so that's the whole idea of it. They lose jurisdiction. Governor Bush is the one that put it out there, and they said, you don't have anything. Now, they took the ball and ran with it. I mean, I had several stand your ground motions I did. I won 2 of them that were in Dade County. And the facts were really relevant because it applies. I have a client who lived in a really bad neighborhood. Gangs were all around there, and they wanted him to join the gang, okay? They were selling drugs, they were doing all this, and he tried avoiding them So he tried avoiding them. They beat the hell out of him a couple times. He has an older brother who's kind of a thug himself, and the brother would tell me he's 13, 14 years old.
Right.
And they beat the shit out of him like 3 or 4 times, okay? Moved out of the city. Couldn't stay out of the city anymore. Went to Miami Beach. Had to move back to little Havana area. And the day he came back, they chased him home, and his brother. And the month before, they beat the hell out of his brother as well. So his mother had a .38 revolver. He took it with him when he left the house. He's trying to get back out of the city. And when he came downstairs, sure as hell, they're chasing him, and he literally was shooting back at them. He was shooting this way.
Oh, my God.
So he was running from them. And hit one guy in the chest, one guy in the leg.
Shooting back.
Yeah.
Impressive.
Was he,
Some John Wick shit right there. Yeah.
well, I don't know who else he shot around him.
Yeah, a few other people too.
Who else was there?
There's a couple dead dogs.
With other,
Yeah.
4 bullets went, but still. Anyway, and it was Judge Anderson. He was really not happy with the case because the one guy had his chest cracked open. It was really bad. He's in serious problems. But when I got him in deposition, he was not the brightest guy in the world. He was telling me about his gang. We were literally on video because and he was showing me his gang signals and everything. So I put all that in the motion, and this guy tried 3 or 4 times to get away from them, moved out of the city. It wasn't happening. So at this point, now they didn't have guns. It wasn't force with force. They didn't have guns, but they beat the hell out of him and his brother a few times before, and they're chasing him again because he wouldn't join the gang.
Right.
They admitted to that, fortunately. So that was the whole thing. That is a really perfect example of how that law should apply. Okay,
Right.
so he's going to sit in his house, and if they come in the house, I can shoot you, but I can't leave my house because I can't shoot you. Then so the law's perfect. But in doing the research for that, the cases that you come across are, I found one case, I don't know if it's held up or not, guy's stealing cars. He's breaking into a car, and the owner comes down, starts chasing him. And the owner's like, pulls out, he's going to get the hell away from my car. And this guy turns around and shoots him. And they said, stand your ground applies to the guy stealing the car at that point.
Right.
And that case might not have held up, but still, you get, as in any law, you get crazy with it. We have the open carrying that's coming out now. It's going to be a shit show, really.
I mean, it's already out.
Yeah, it's already here.
Right.
Yeah.
So that is a shit show. I mean, I can't even imagine where that's going to go. I mean, they have the exceptions like in a school building near a school this, near that.
They're not except they were the same rule that you had before. You couldn't carry a gun whether it was concealed or not
Right.
in those areas.
Right.
But now you just can't open carry. Although Publix just came out of it in the paper yesterday, we're allowing open carrying.
Oh, really? So you can walk into Publix now with a gun?
You could do it before, unless you put up a sign that says no guns allowed here.
Yeah.
Which elevates the trespass now to a felony because it's armed trespass if you walk in
Oh,
with a
wow.
gun and you don't leave. So if Publix or 7-Eleven says, hey, get out of my store, and you don't get out, it's trespass. Now if you have a gun on you and you don't leave, it's felony trespass.
Oh, my
So that's going to be a whole thing.
That's
And you have a
good.
lot more phone calls. Hey, this guy's walking down the block with an AR. And
Yeah, you can't do anything. It used to be it was fishing or hunting or camping were the 3 exceptions. So you'd have those jackasses that would go out there and bait cops by going out on the Dania Pier with their AR-15 strapped across their back. And then, of course, the BSO who, not going to say anything.
Yeah, don't.
The police officers who did not know that the law existed for open carry while you're fishing would show up with their guns drawn, and these people would be like, you're going to get a lawsuit, bro, because they're just
How'd they
baiting
say
them
it?
to, hey, you're going to get a lawsuit, bro.
It sounds like a Miami, like,
it's Dania.
It's like there's these people that go out there and just bait cops into
Oh, when I was a
situations.
kid,
It's so stupid.
And as a kid, everyone in Davie had a gun rack in the back of their truck, and the shotguns were on there. People went to school that way in the 80s.
Right.
So you always carry shotguns, hunting guns in your back of your pickup truck. Now you can do it again. That's all.
But, the thing is with open carry, anybody who open carries is kind of stupid because, I mean, if your objective is
you're
self-defense.
creating stand your ground for half the people you run into.
Well, no, if your objective
If you walk
is
up and you have a
self-defense-
gun on your waistband, you say, hey, screw you, and the guy shoots you,
Yeah.
you could say you were provoking and you had a gun on you. I don't know, he could kill me.
I don't
Think
know
about
that.
that. I mean,
My biggest
obviously, I'm
problem with
exaggerating
it-
a little bit, but you know what I mean.
Is if you're using it for self-defense, somebody walks in with the intent to commit a crime and looks around and sees you open carrying, that's a big sign that says shoot me first.
Right? It's dangerous. I just,
It's not a bright idea. you'd prefer for nobody to know you have it.
I know a guy that if you're in the military, and I'm speaking out of school here, this is just what I heard. The guys on the top of the Humvees that have the
Yeah,
50 cals,
yeah.
whatever, those guys had a 4% chance of living going through the area because they're the first ones that would take out.
Yeah.
That was
Right.
the idea of that.
Yeah,
So,
you're the most exposed, and you're obviously
That's
the
it.
biggest
You're
problem.
right, exactly. And they're the ones, the first ones to take out. You're right. So, but still, carrying a weapon concealed is still pretty. This is a whole other podcast. It's useless. It's a useless weapon.
No, it isn't. I'd argue with you that it's actually better. Like, it's better. I think open
Well-
carry, like, how I would use it is just to be able to walk around with a concealed firearm without worrying about the little
That's
fucking
the huge
minutia.
thing. That-
you know?
you don't have to
The
worry about
minutia of
some cops
package,
saying-
and is it secure, and all that dumb
Oh, cop saying,
bullshit
I saw
anymore.
the butt of his gun coming out, or he reached up to get something on the shelf and his gun was exposed. That's it. You're open carry and I can arrest you. And you may think it doesn't happen if you're not in the world that we're in, but we see many cases all the time. And it's usually probable cause to go stop somebody. I saw the butt of his gun, and if you're printing, which means you just can see the outline
Just the
behind your
outline
shirt,
on the shirt.
then it's, a cop can say, I saw it, okay? Now, yes, I know not every cop's going to say that, but listen, if you're a cop and you see a guy with a gun, you really should be looking at him. You should be watching what he's doing.
That's another thing. I was going to
okay?
say law enforcement encounters are
Yeah.
going to get way more heightened. Can you
Yeah,
imagine?
that's it.
Yeah, I don't know. Everybody was going nuts about how Florida's going to turn into the Wild West when we got constitutional carry, when we did away with the need to have a concealed carry permit. A lot of people were freaking out about that, saying, "Oh,
That was
it's
only
gonna-
like 6 months ago, wasn't it?
Yeah, there's going to be
July
so
last
many
year.
drive-bys and deaths, and hasn't happened. So I mean, I think that most people with common sense are not going to open carry. And I mean, unless, I can't think of a reason other than like hunting or fishing. Well, not even fishing. You don't fish with a gun. But I think most people who do carry a gun have a little bit of common sense. And I think that
Do
they're
you?
not, yeah. For
You
the
think
most
that?
part.
Yeah, I mean, I think honestly, I think the conservatives that are carrying guns usually are usually more controlled with them, you know, than, you know.
I don't think most people have common sense in general, much less
That I
ones that
agree
carry a
with.
gun,
That I
so.
agree with. I mean, yeah, it's just it's a dangerous recipe. So we'll see.
A lot
where
of
it
states
goes.
already had it, though. We're kind of falling behind in that.
Yeah, well,
It's so funny. It seems like-
constitutional carry is the norm in most states, but I just went up to New Jersey, and if, I didn't take my gun with me when I went to New Jersey, even though it was Newark, so I should have. But when you go up to New Jersey, you know, once you get in the car, it has to be in a locked container, and I think you have to put it in the trunk or something, a locked container in the trunk, but then you get over to Pennsylvania, which is only about 30 miles away, and you can conceal carry.
Yeah, at
Because
some
30
point
miles the other way in New York, you're
The
screwed.
feds are going to have to kibosh some of this stuff.
That's
because
it.
it's
A
getting
lot
too
of laws
inconsistent.
conflict with the
Right, there are
federal
too many
laws, so that's
conflicts.
the
I know
problem.
I'm in New York, I can pick up a life felony or whatever, like, and I'm here and it's completely okay. It's just too confusing. That's the whole point of listeners of the Commerce Clause. Like,
Yeah.
if it affects too many states and it becomes too inconsistent to be from one state to the other, they can get involved and they can make a uniform law, you know, especially if it affects, it does. Like Jersey, what's Jersey's law?
Jersey, you have to, well, they don't have, every state has to have the ability for you to get a concealed carry permit, but they're very restrictive on who they give the concealed carry permits to. And I think only 2 were issued in 1 year. And so it's impossible to get one there. And so there's no reciprocity with Florida's concealed carry. So when I was up in New Jersey, I would have had to keep my handgun in a locked case and put it in the trunk of the car.
Right.
I was seeing a lot more protective orders coming in for BSO taking guns, people who have mental health issues.
Well, it's not even, they do it for everything now.
Well,
The risk protection order, that's a new thing. I see it all the time.
It's not new, but
Anytime
it's-
now it's enforced.
They're doing a lot more of them, that's what I'm saying. That's going to be kind of the balancing act here, you know? We'll give you the gun rights, but they will give us something and they'll act on
But
that.
they're, you know how they're enforcing it? It's so ridiculous. We need to take the firearm for a year, but you could hold on to it.
When you get-
No, like, I can hold on to his firearm, the lawyer? Yeah, as long as you have it for safekeeping. I'm like, okay, great. Now
Well,
I
that's
have
a
an
lot of
office with
guns.
50 firearms in my office, you know,
Well,
like,
the sheriff's department has a lot of guns there now, too. And so some of these guns are worth a lot
they're
of money.
hoping some people won't pick them up, you know? Like, we have a fire sale after a year, you know?
Well, that's the idea of it, I guess. There used to be a law that cops, you know, can take a gun and have a judge sign off on, you know, confiscating it or something like that. You get a nice chrome-plated Colt 45 or something like that.
Exactly.
Yeah, they would want that one. So,
Like the cop car, the Corvette that goes by the cop car,
A
right?
lot of states take the guns that go into, what's it called, into evidence. And once there's no longer any use for them, a lot of states auction those off.
Right.
Really?
So that's, there's a
They
website
used to
called
destroy
Evidence
'em.
Room, where you pick up like the little ghetto blasters, all right, like the 25 caliber
We used to-
Ravens and stuff.
we used to go down to the evidence room. We were a lot, I don't know if you still can or not. I haven't done it in a while. And you have a gun case, you go down, the idea is that when you go to trial, you don't want to be holding the gun and looking at it for the first time.
Right.
Even though you know what a 9mm Beretta looks like, you still go see that one, and you'll have it, you can hold it, they'll show it to you, it's obviously safe. When you went down there, not one gun was worth a damn out there.
Right.
It's like, all the ones they see is like, someone tried, this is blow up in your face or something.
Yeah,
So
exactly.
it's
They were
like-
like rigged
Yeah, they
up
got
guns.
like,
and then you walked out stoned because all the marijuana is sitting on the one side of the evidence room. It's like, whoa, how do you guys survive here?
where are the powders?
Yeah, the cops in there just giggling at you. I'm like, oh my God, you guys got to
You
take a
got
lunch break.
Frito-Lays everywhere,
Yeah.
bags of chips everywhere. I don't know why.
But listen, I wanted to move on to a topic that I think is important that most people don't understand, and hearsay. I want to just flush this out a little bit, because I know that we have a pretty good understanding of what hearsay is, okay?
I heard you say it.
It bothers me that nowadays, I had a guy argue with me today about like the Charlie Kirk thing. I don't know if you've been following it, Larry. Like there's a text message where he said he was leaving the Israel cause, and he put out a text. This Candace Owens idiot put it out there, right? So then his friends
with the disrespect
commented,
to Candace
she's a
Owens.
fucking idiot.
She's hot.
She's disgusting. So then his friend came out and said, hey, this is bullshit. This is my friend. He didn't mean anything. He was just blowing off steam. So I had a person argue with me to my face today saying, that's so ridiculous that he would put that text out. I'm like, who, the friend? He's like, yeah. It's the same value as the guy that's known him all of his life commenting on what the text means. It's all hearsay, right? I tried to explain to him that none of it would be admitted in a court of law, right?
No,
Guy looked at me like I fell off a... I mean, the text is getting in under dying declaration. Yeah, what's the exception? If he got shot while he was texting it?
Well, the funny thing, you hit on a really interesting point. The funny thing is, and I remember this from law school, whenever we had the exam on evidence on hearsay, like 9 out of 10 questions, the answer was, it's not hearsay. Okay?
Right.
Everyone's looking for the exception to it, but it wasn't hearsay in the first place.
Right. Well,
You
let's
guys know what they-
define hearsay.
Out-of-court statement offered, testified to in court. for the
Out-of-court
purpose-
statement offered for the truth of the matter
Testified to
asserted.
in court.
Offered for,
Only evidentiary value is for the truth of the matter.
for the
asserted.
truth of the
Right.
matter asserted,
So,
right?
but it has to be testified to in court. If I'm sitting there making statements to the cop outside, it doesn't make a difference.
Right.
It's testified to in court. That's where it becomes
That's where it becomes,
unreliable.
that's where it becomes direct evidence.
Well, that's where it's
Well, here's the
liability
thing.
is weak.
A lot of people think that, hearsay is very broad, but it's actually pretty narrow, because there's a lot of exceptions. What are there, like 23 separate exceptions? My ex-wife's attorney always used to say stuff like, not for the truth of the matter asserted, effect on the listener. That's the only exception she knew.
Pick one,
All
and that's all he went with.
And I was just like, for God's sake, there's 21 others, lady, can you fucking think of one?
And then usually she was wrong.
Yeah, and she was just dumb.
Right.
And yes, it's you. All right, so,
Right, but like a text message that's sent to another friend without that person testifying to the text or receiving the text is
Well,
hearsay.
Listen, those exceptions kind of make everything come in, okay?
That doesn't,
Effect on
but
the
that doesn't
listener,
come in when I just
effect on
gave
the
you.
listener.
That doesn't come in. That text message I just said
Which
comes
one is
in.
it? Say it.
It's a
What's it
text
say?
message by a dying person. Charlie Kirk allegedly sent a text in his group chat of Turning Point people.
okay.
Just lost money from a Jewish donor. These
Figures.
Jewish donors play they play under the stereotypes. They're going to force me to turn away from the pro-Israel cause, right? They took that text, and she's using that now, this Candace Owens, to show that he was turning away from Israel and that Israel assassinated him. So the truth of the matter asserted is that this is proof that he was turning away from Israel and that Israel has probably killed him.
No.
There's
no,
nobody
back up.
testifying to this. This is just a text message from him, right?
It's not testified to in court. Doesn't matter.
Back
Yeah,
up on that for a
exactly.
second. The only truth of the
It's not
matter
that it's
asserted,
hearsay, is what it is.
the only truth of the matter asserted was that he would be turning away from Israel.
Okay.
All right, exactly what it says.
Okay.
That,
Well, that's what she's
the only-
offering it for,
okay.
right?
Well, you could go ahead and you could offer it for his state of mind, that he was becoming increasingly agitated with the Israeli donors. You could offer it for that, but you couldn't offer it for the fact that he intended to turn away from Israel.
She was offering it to show that he was turning away from Israel.
Okay, but you also got to remember that hearsay is only in court.
This is a,
All I was saying is that if it was in a court, there's a reason
Yeah.
why. There's a reason why in court it's not in. You know why?
Because it's bullshit.
Thank you. That's all I was trying to make a point of, right? I know we're not in
Because
court.
of
That's what he
defense.
kept saying to me. But we're not in court. Like, I know we're not in court. I'm trying to make a point to you. If it wouldn't even be admitted there, because you're trying to judge whether something happened or not, really judge with critical thinking, what the fuck are you taking it so seriously for on fucking social media for? You get what I'm saying?
No, I understand. It's like people always say,
But we're not in court, he kept saying to me. I'm like,
people
dude.
say stupid shit like,
if you're studying for the bar exam, don't use what we learned here on hearsay, okay?
Yeah, but at least not when Larry talks. But
Two
go
taps
ahead.
of friends on
At least
evidence.
not when Larry talks, okay?
taps of friends on
you know,
evidence.
when people say like, oh, so this, somebody's innocent until proven guilty, that's in court. That's the instructions juries have to follow. That's
Sure.
not what I have to feel as a person.
Right.
All right. I can go ahead and look at a case and be like, that dude's pretty fucking guilty.
Right.
All right. And that's not a violation of anybody's
Not at
constitutional
all.
rights.
Not at all. But if you're trying to convince me and showing it to me as if it's this amazing airtight case, I'm going to take you apart. You get what I'm saying?
Well, yeah, because people think
You're
that-
allowed to fucking follow whatever theory you want. You could sit here, you could believe that aliens created unicorns and the unicorns make cheesecakes. I couldn't say a fucking thing. I don't need you to
They
prove
don't?
it to me. But if you try to prove to me that, I would take you
cheesecake.
apart, right? I would take you apart, especially with a text message.
You lost me
know?
at cheesecake.
Yeah, so
It doesn't take much to lose you.
Yeah. Aliens and cheesecake. But at the same time, anybody,
We're not in court. You don't
All the-
believe
yeah,
me? I can
exactly.
say whatever I
All
want to
the-
say, dude. Like
all
what?
these people say stupid shit like, oh, innocent until proven guilty. Oh, that's in court. All right, I can go ahead and feel any way
That I
I want
agree.
to.
There is no innocent until proven guilty outside of court.
most
right?
famous
You're guilty
line-
till proven innocent anywhere else. You
The
know?
most famous line I heard, is a juvenile judge, he was great, I won't mention his name. He was just,
Does he hold an unlit cigar?
no,
Okay, all right.
before him. And we're in the middle of a trial, a juvenile trial, and I object. I said, Judge, it's just hearsay. He said, I know it's hearsay, but I want to hear it.
I think I know exactly what
Fair
judge
enough.
that
At
was.
least
I got nothing.
it's getting in because I want to hear
I
it.
got
You know?
Did he handle one high-profile case?
Yeah, man.
Exactly one high-profile.
Oh, I know exactly who you're talking about now, right? Right?
Yeah.
He was a great guy, though. He was
He
amazing.
really was.
But then we had the other
Did he
one.
pass away? He's
Yes.
still around.
No, he
You
passed
already
away.
killed the guy?
I didn't kill him. No.
Okay.
But we had we had a trial. Remember? Mention his name. We had a 20-minute argument that this is hearsay. It's hearsay. It's got to be hearsay. Fortunately, we got a not guilty on it. The next day, we're in that division. Same judge. He's like, Mr. Schweiker,
I
Mr.
remember
Rosenberg.
this.
That argument we had? I go, yeah. Judge, he goes,
You were
I go,
right.
he's, well, if you would have argued Crawford case, I would have agreed that it's hearsay. It was hearsay before Crawford.
Yeah, what does it matter, dude?
I
Exactly.
said, whatever you want, Judge. Okay, that's all.
Remember when he had that one argument with,
But the point is, that people want to hear everything. They want it to come in. You have 23 exceptions to it. It can come in probably, okay?
that one argument we had, it was the sex bad case with the kid, and I was arguing, Your Honor, there has to be penetration in order for
Oh, my God.
And then he's like, I've tried 56 sexual battery. I know there has to be penetration. And then he goes ahead and he gives us a directed verdict at the close of the state's evidence, not guilty on the sex battery. Right? Then I go back and I'm just like reading over some stuff to prepare for the defense side for the lesser included. And here's this case that says, penetration means contact. There does not have to be an actual
I remember that. We were there together.
Yeah.
And at one point he goes, I'm going to go back and I'm going to watch all the videos and see penetration. We're like, oh my God. And we're like, you do whatever the hell you want to do,
He was like,
Your Honor.
He was like
I
this
remember that.
folder. He's like, did he touch her outside
Yeah,
of
was
the
it
panties or
inside
in
the panties?
the panties?
It was so
And we're
bad.
like,
I'm like, what the hell are we doing? It was a Friday afternoon, too. I was like, I'm done.
I mean, you
can't.
remember in law school.
He's
the
like, I'm
first
going to watch
time-
all these videos in my chambers. We're like, you go to.
and he just fists the file, and you're just like, what the fuck?
The first time in law
God.
school, you read a
Can't believe you
sexual
just said that.
battery statute, it's, you watch the people around you squirming. Oral, anal, or phallic penis touching the vagina, oral, anal, penetrating, it's like, people just like, this is law school. I didn't go to med school. What the
I
hell?
got up at one time in a jury selection, and I go penis, vagina. I go blowjobs. I start just, and everybody's like, what is this guy doing? I'm like,
He has
and
sex Tourette's.
everybody should go take a shower after my jury selection. Everybody started laughing, like.
Was it you that had the?
But you had to like get the shock factor out, right? I wanted to
That's-
see what they would react
Howard
to.
Finkelstein is famous for that. He had a case with, where sex toys, dildos were all about the case. So-
Yeah.
and he's like, I got to desensitize this jury. So he had a box full of dildos and threw them into the jury
Where'd you get?
box.
I don't want to know the answer to that question.
There was one where.
Oh, we
Question
had
is, how many
it's
did
in
all-
the closet, the public defender's office.
Wait a
We
minute,
keep 'em
I
there.
threw 12 of these out.
Yeah.
Only 10 came back.
Why does this one have your name on it? Like,
there
Why,
was,
why is only 10 coming back? What's the other two?
there was
oh
one
wait a
case
minute,
where
that's
the
my
guy,
shirt. You know, like.
this guy's defense to the rape charge was that his penis was too small to do the kind
I
of
remember
damage,
that. I remember
and
that
it
case.
was caused by the aggressive use of she aggressively used a dildo.
Oh, my
And I was just like, now, and then he appeals this, right, because he got found guilty. And it's like, would you really want to go out there and
In
have
front
it,
of all
you
these
know,
judges again?
and be like, I'm sorry, my penis is too small to do any damage. Like, first off, after I saw, like, childbirth, like, the thought that my penis ever hurt anybody, it
Oh
just
my
went flying
God.
out the window.
All right, we need to
that-
move
is that on your list
We
of
need
stuff
to
we're
move
talking
on.
about?
We need to move on real to this.
So
was
far,
not on my
childbirth,
list.
fisting, what else
we
you got,
went
Mike?
from hearsay to Michael Dye going off on rants and talking about his personalized dildos. But, yeah, so I just wanted to talk about hearsay. I don't know if anyone got a better picture of what that is after all this, but basically, it's an
Two taps takes it to the next level.
We definitely took it to the
Out of
next
court
level.
statement that's only evidentiary value is for the truth of the matter asserted.
Right.
Boom.
In other words, and there's exceptions, you know, but
19 or something,
You
or
gotta
20.
really
in
be a
court.
scholar to it. But the point is that what we hear nowadays is in court, half of it, 90% of it would not be admissible. It's all innuendo and bullshit, and it's hard to get an assessment as to what's real and what's not, you know. Last 10 minutes of the podcast, I wanted to talk about the difference in jury selections and murder trials, right? Larry, you want to take that a little bit? Talk about the difference. Because we talk about jury trial. I just had Eric Schwartzreich on here. I just had all these guys that are experts, and Johnny Weeks, and all these guys talk about it. We've talked about it. Talk about the big differences here.
Well, here, especially if you have, number one, if you have guns involved, that's a hot topic.
Right.
And if there's any case that has a hot topic where people are more sensitive is where you have a problem, okay? That's number one. Or it's a problem for two reasons. One, it does affect people. Some people just can't stand guns. They can't look at them. They can't have them around them. They think no one should have a gun. That's their God-given right to believe that. But you can't sit here and not be focus on my case if you just can't get past the fact that there's a gun here. Like, you lost me when you said gun.
Right.
Same thing with sex cases. Hey, listen, I can't do a sex case. Okay, that's all there is to it.
Right.
My analogy I use in jury selection is, hey, if you're not right for this jury panel, let us know. I'm an asthmatic. I have asthma pretty much all my life. If I was a juror on a case against the tobacco industry, I probably wouldn't be the best candidate for that jury panel.
Right.
I have some version of a lung disease, I guess. So that's why it's important. And you see when you have these hot topics, you have more jurors come in because you know you're going to lose more.
Right.
And that's a big problem because now you have, instead of 22 people to sit there and talk to, where 22 is a really manageable number. I can memorize their names. I can talk to them individually. I can remember that this guy in the back said this and he's talking to him about that. When I got 80 people there, or I got to do this in groups of 40 come, then the next 40 come after we get rid of them, I'm talking like, this is the same shtick you had before. What are we talking? Why are we hearing this twice? you
Right,
know?
right.
So you lose that whole personal touch with it. So that's a problem number one.
Right.
And then if you have guns or dead bodies, someone just lost someone, everyone knows of a death in their family. And if it brings it back to that, or it's too close to home, they can't be on that. So you have more people. That's the number one problem.
Right.
You know, it's rare that you have a grand theft auto case and says, hey, you know what? back in 1985, my car was stolen, but I got over it, okay? I'm
Right.
okay with that, you know? It was a piece of shit car anyway, it never started. Air conditioner was broke, radio's broke. I'm glad they stole it. That person's still going to be on this jury panel. You know, hey, I got to listen to someone getting shot. My nephew got shot and killed in the street. I'm not going to get over that.
Right.
That's all there is to it. So that person can't be, and they probably tainted 5 other people while they're talking about this.
Right, and just being affected by death. I think everybody's been affected by death
killing,
and lost
yeah.
somebody, right?
Yeah.
Like whether it's killed or whether it was a car accident, whenever there's a death, you know, they have to bring so many more people off because they know we're going to exclude so many people, or some people are going to just jump off for cause, right?
Well, you had to talk about that. Like you said, we just talked about the desensitizing people with the sex stuff and everything. But I remember I was in Martin County doing a murder trial, and it was a shooting. It was guns. There's lots of guns involved in this house. It's Martin County. So I asked. We had like 55 people. I asked, how many people here we're going to talk about guns? Is that a problem for some people? How many people here own guns? All but 3 people raised their hand. Okay, first of all, we're in Martin County, so like, it was a different story.
Right.
Okay, we're good, I guess.
Right,
We'll move
exactly.
on to the next thing. I had 20 minutes on gun stuff, and those 3 people, like, we don't own them, but, yeah, they're just in the middle of getting some, that's all.
Right,
So,
right.
and that's it. So it's area affected. I mean, you go, different crimes are really more, you have a drug case in Miami, it's different than having a drug case in Pensacola.
Right.
So that's the type of thing. So, yeah.
100%.
So you have to know where you're at. When I try cases in other counties, I kind of try and hang around. If I go to a status hearing, I'll go and have coffee in their
You
in their
get the
diner.
vibe.
Yeah, you got to get that. Yeah, you
Yeah,
have to see what
Schwartzy was
that's
just in here talking. He was just saying he tried a case in
Well, one of the things that,
Okeechobee, I think, and he said like he was like my cousin Vinny in there. He was
I
like,
eat lunch there every
They were
day.
just looking for the show,
Yeah, at Okeechobee, I made sure I went to it's the Brown Cows, really cool place, like great brownies. I sat there for an hour or so after every hearing, just to make sure, listen to the people, just see them, just get the
Right.
the vibe.
the lay of the land.
Yeah. What are you saying?
I think one of the things that kind of surprised me when I initially moved up to North Carolina, I was used to, I'm used to Broward, but I love practicing in Miami. Everybody loves practicing in Miami if they're
course.
criminal defense.
Of course.
All right, and so then I'm doing mostly Broward and Miami, and then I go up to Raleigh, and one of my first cases was a guy had, I think it was something like 1/10 of a gram of cocaine. It was just like a little bit of dust in the bottom of the bag, and it kind of like one of the old "Where's the Beef" cases down
Right.
here that they started dismissing.
Right.
And so I'm like, oh, this is nothing, and shit. And so we go inside, and I'm talking to the prosecutor, and she's like, this is a very serious charge. And, I'm being from down here, and I'm kind of a smart ass. I'm like, you could vacuum my car and find more than that. All right? And
That's typical.
then,
I mean,
the attitude when you switch areas, like when you go up to Martin County or Okeechobee, places like that, it's really important to get a lay of the land and the way that people react to different crimes, because I can tell you that drug crimes were taken a lot more seriously in North Carolina than they are down here. DUIs were taken a whole lot more seriously.
Right.
Down here, we could actually, when we take DUI cases to trial, we can win them.
Right.
All right, there's a lot of cases that a lot of people don't think that, but up there,
you still have dry counties in Carolina.
I don't know about anymore, but you used to.
but up there, what happened was your first trial is a bench trial, and then the Raleigh News and Observer started publishing the different judges and their conviction rates for DUIs. And all of a sudden, the conviction rates flew through the roof.
Oh, yeah.
Because the judges didn't want to get the soft on crime look. So the cases that would be easily won down here were guilty
Right. Well,
on
they're
everything.
in the hands of a
When I was
judge.
in D.C., I was in law school, and I was an intern with the public defender's office, and there was murder trials were every single day. It was the murder capital of the world
Yeah.
at the time, and it was not uncommon. Their theory was it's an aggravated battery with one less witness. That's what the idea was, because there were 2 or 3 day trials. Boom, boom, boom. There's so many murder trials. Murder was like such a second nature. And to hear it didn't taint juries. I mean, yes, people were horrified by it, but it didn't, we hear about it every day. Every day. I saw 3 people get shot and killed in D.C. when I was there.
Wow.
And I grew up in South Florida.
Different
So,
times?
Yeah.
Wow.
Different times.
How long did you live there?
4 years?
Yeah, I think it's much better now. I venture to say it's better now.
Yeah, well, I don't know. It's,
Maybe not, I don't know.
I mean, I was also, we're doing private investigation stuff. I was in Anacostia, the really bad area, so.
So you were in the prime areas to see it.
It's not a very small neighborhood. The whole area, the whole area is a prime area, so.
Yeah, I think it's a good place to wrap. I don't want to go too long as we lose people. I think we had enough
And dangerous, Mike's gonna say.
interesting conversation today, dude. It could probably get us in a little bit of trouble, but it's okay, you know?
I didn't say anything that could get us in trouble.
Not at all. I've been saying stuff that gets me in trouble every podcast probably, but thank you guys. We'll give you guys updates on our trials later on and see how they go. We got a long month ahead of us, Larry and I
I can
especially.
tell you now how it's gonna go.
Yeah, well, we're not gonna say that, but thank you guys for coming on. Mike, I appreciate you always coming on. Love you. But Larry, thank you, my trial partner, for coming on and making your way up here. I had to convince you to get on here, but thank you for coming
Yeah.
and complaining about traffic the whole way up here. But to all our listeners and viewers, thanks you for listening. Please like and subscribe to the channel. Like I say, when you like and subscribe to the channel, it gives us more outreach. We get more panels like this on, more guests on. You can follow us everywhere. We're on YouTube, we're on Instagram, we're on Facebook, we're on Spotify, we're on Apple Podcasts, we're everywhere.
MySpace?
Wait, what?
MySpace?
We're not on MySpace. If it comes back, we'll be on MySpace. But thank you guys for listening. We love you all. Hope to see you guys soon. Thank you so much. Goodbye. Cut. We're good. Thank you, man.